The following is a PowerPoint presentation presented in federal court in Fargo, North Dakota during a hearing held on April 24, 2019, during case number 319 CV29, titled Ernie Brookins versus Caterpillar Inc. The contents of this presentation proves that Caterpillar committed a fraud on the federal court system on March 3, 2017, when they filed the IPR containing false information with the Patent Board as well as with the federal court in Fargo, North Dakota, by calling Ernie's 290 patent a CVT. I have recreated his exact wording. Gail Brookins.
Today is April 24, 2019. It is 10 a.m. We're here for oral argument in two cases. Both are captioned Ernie Brookins versus Caterpillar Inc. The case numbers are 319CV13 and 319CV29. Mr. Brookins is here in the courtroom this morning. His wife Gail Brookins is also seated with him. And is it Mr. Swenson representing Caterpillar? David Swenson representing Caterpillar along with Jane Dines.
We have displayed the letter from Caterpillar sent as demanding what we do. I received this letter from Caterpillar on April 3rd, 2019. It's the second letter I've received from Caterpillar demanding I dismiss my lawsuit. The first, sent on January 20th, 2017, threatened to file an IPR that contained illegal, false information about my patent. This second letter states, quote, Caterpillar demands that you dismiss your complaint in case number 319 CV29 immediately. If this case is not dismissed, or if it is dismissed in North Dakota and refiled elsewhere, Caterpillar will have no choice but to serve a motion for sanctions on you pursuant to Rule 11C8 for filing a complaint based on the 290 patent, unquote. I did not take these threatening letters lightly, but I will protect my patents. I will not dismiss this lawsuit. I will agree not to refile it elsewhere. The reason why the 290 patent case should be held here in this court, beginning with the history of the patent. I filed an application for a patent through a patent attorney. He filed 2 provisionals, and he filed the application on July 30th, 2007. The application was for a hydraulic clutch. I also wanted to patent the hydraulic clutch working as a CVT and the hydraulic clutch hybrid design. The history of the patent in this court, understand I've had 9 issued patents. The sliding shaft transmission patent was the first one. It was a manual transmission issued March 30th, 1998. And as you can see up on the screen now, we're showing the patent, the 290 hydraulic patent, as 110. The second transmission and clutch assembly patent was issued on June 8, 1999. All of my transmissions have a hydraulic clutch, not variable speed. They're all clutches. The first court case we had in this courtroom with Judge Webb was over whether the 290 patent was a hydraulic clutch or not. Okay. These clutches of my patents are only used to take off with the vehicle, just to get the vehicle moving. You apply the hydraulic clutch to move the vehicle. Nothing about variable speed, you just get the car moving. Then, when you shift it direct into high gear, it's 1-to-1 gear ratio. That's what clutches are. According to page 8 of the 290 patent application, Figure 1 is one embodiment of a rotational power distribution and control system configured as a hydraulic clutch. Figure 2 is a diagram of Figure 1, and Figure 3 is another embodiment of a rotational power distribution and control system configured as a hydraulic clutch. Page 9 of the 290 patent lists Figures 4A and 4B as diagrams of embodiments of a rotational power distribution and control system configured as continuously variable transmission drive systems in a vehicle drivetrain. It lists Figures 5, 6, 7, and 10 as a hybrid drive system. For the next 2.5 years, I worked on developing and perfecting my product built to all 3 of the species of that patent application. I built a prototype model and installed it in a 2003 Ford Explorer Sport Track for testing. I displayed it publicly, giving rides to people, and there was a newspaper article written about it. We applied for some grants from the state of North Dakota and got them. On December 1st, 2009, the patent examiner sent an office action requiring a restriction. He listed 3 different species in Ernie's patent application, which were Figures 1 through 3, which show a fluid valve controlled resistance brake for a planetary gearing. Figures 4A, 4B, 6, and 10, which show a hydromechanical CVT with a planetary gearing, and Figure 5, which shows a hydrostatic pump motor acting as either a brake or a drive source for a planetary gearing. He used the Patent Office MPEP Section 802 Rules for Restriction, quoting the rules of 35 USC 121, saying I was trying to patent too many things, giving me 30 days to select one of those 3 species. Since the CVT and the hybrid species wouldn't work without the clutch, I picked species 1, the hydraulic clutch. I withdrew and canceled all drawings and claims to both species 2 and 3 as required. On December 28, 2009, I sent my choice of Figures 1 through 3 along with 21 claims and my notice of withdrawal of the CVT and hybrid species along with Figures 4A, 4B, 5, 6, and 10. In that notice, I also argued against the restriction. I provided a claims listing to the patent examiner on March 26, 2010, showing all 19 claims to species 2, the CVT, and species 3, the hybrid, withdrawn. The examiner did not agree with my argument against the restriction. He understood my patent completely, stating, Species 1 is not used to power a drive wheel. He noted that claims 15 through 40 are withdrawn from further consideration pursuant to 37 CFR 1.142b as being drawn to a non-elected species, and the restriction was made final. The 290 patent issued on November 2nd, 2010. The final claims listing showed 30 claims relating to the CVT and hybrid species as canceled. We see here the demonstration of both types of clutches today that's in automobiles. A clutch is a coupling device that's necessary to couple and uncouple the engine from the drivetrain in a motor vehicle. Before my patents issued, as we see, there was only 2 types. The type that's in the car, that has a standard transmission in it, which has a clutch disc, And then you have the automatic transmission too, and it also has a clutch disc in it. The way you apply the 1 is when you release the clutch pedal to make the car go, then it's coupled up 1-to-1 gear ratio to the transmission. In the automatic one, it's like all my patents, it's applied hydraulically. So the clutch disc, when it's applied, then it's 1-to-1 gear ratio. The clutch has no gear changes, no possible gear changes in it. My hydraulic clutch, which is marked number 110 in the 290 patent, is the third type of clutch, or positive displacement torque converter. It's the only positive displacement torque converter today in the world. The patent examiner stated, quote, "It is not used to power a drive wheel or start a vehicle. The pump of species 1 is used for the purpose of retarding the rotation of the planetary gear set. This is not a case of the pump and motor of the other species. The fact that all the embodiments of species 1 are present in the other species does not mean that they are not separate and distinct inventions. It is what is different that sets them apart." Unquote. One of my favorite statements is, I have to explain to people that you have to apply the brake to make the car go. The RPMs of the engine does not control the speed of the vehicle. It's controlled by the resistance of the weight of the vehicle. On June 26, 2013, I filed a patent infringement lawsuit against Mac, Inc. because they were infringing on my 290 patent. Mac claimed my patent had to have a planetary, while I said it didn't. Judge Erickson held a claim construction hearing on the term gear set, and if my patent required a planetary, right here in this courthouse. In his decision, he listed at least 3 reasons why it didn't have to have a planetary gear set. He used testimony of experts from both sides. He used the definition of the word coupled out of the patent, and he said I broadened my patent according to the law, so it did not require a planetary. After Judge Erickson ruled in my favor, Mac approached me and the case settled. Part of that agreement included a large cash settlement to me and licensing rights to the 290 patent to Mac. Mac was purchased by Generac, a major manufacturer of industrial power equipment and generators. They continue to manufacture and sell the Mac flameless heater today. There are 4,000 to 5,000 Mac heaters today containing my 290 patented product working in the oil fields of North Dakota, Montana, Wyoming, and Canada. I also licensed the 290 patent as a hydraulic clutch to Multitech, and they paid a large cash payment to me. Multitech applied for a patent listing me as inventor, which is assigned to them. It is patent number 9995508, issued on June 12, 2018. Now you can see it up on the picture, and it's just the hydraulic clutch. It has nothing to do with drive wheels or anything. My patent is only a hydraulic clutch. None of the Mac or Multitech heaters contain a planetary. It's not necessary. On August 9th, 2016, I filed an identical lawsuit for infringement of my patent against Caterpillar Inc. In their claim construction brief, they used the same argument as Mac, that the gear set in the 290 patent had to be a planetary. Caterpillar knew about the restriction and they knew about Judge Erickson's ruling in the Mack case, and so they knew they had no chance to win with the planetary argument. They knew making that argument in the Markman hearing would result in a guaranteed win for me. So they sent me a letter on January 20th threatening me with a draft IPR if I did not dismiss my lawsuit. So right there, they're demanding that I drop my lawsuit or they would file the IPR illegally. I understand those draft IPRs are commonly called dark IPRs, and they use the price of an IPR attorney to scare the little guy into withdrawing the lawsuit. That draft IPR contained their argument that the 290 patent was a CVT, and the previous art they listed was a CVT. After Gail read the IPR draft to me, I knew the only way they could file that document was to commit fraud on the federal court system, so I did not, under their demands, dismiss my lawsuit. Now we can see right up there on the picture, 110 is the hydraulic clutch. Nothing to do with the transmission. It's a hydraulic clutch that works independently. On March 3rd, 2017, Caterpillar filed their IPR with the Patent Board at the Patent Office. They also filed a copy of that IPR with this federal court in Fargo, along with their motion to stay the proceedings here pending outcome of the IPR. In it, they used the same argument as in the draft IPR, falsely calling my 290 patent a CVT. Now that was a flat-ass lie. They knew my patent was restricted to a hydraulic clutch because one of their exhibits was the prosecution file of the 290 patent. 3 of the previous art that they used was CVTs. Now let's look at the picture. In the IPR, Caterpillar claims Figure 1 of the 290 patent and Figure 1 of Kaiser are remarkably the same. The Kaiser patent is one piece. The 290 patent drawing shows the hydraulic clutch is one piece, 110. The pumps are similar. How the pumps work is totally different. Kaiser is a CVT. The 290 patent is a hydraulic clutch. Now let's look at this up here and see why it's impossible to make, and why all 3 of their previous art is on planetaries, while 110 is a clutch system. The input shaft drives the pump motor. They go to their pump and say it's similar, which it is, but the input shaft from the engine goes and drives the sun gear. The planetary has 3 different pieces. It has a ring gear to the output shaft and the sun gear. You have to hold at least one of the pieces to make it work. So the input shaft comes into the planet gears, and the planet gears turn the ring gear, and when it's in neutral, the sun gear is just idling. In order to make the car move, you would have to apply the pump, and then you only have a single speed planetary. That means that the only speed you have is when you put the transmission in low gear to take off. So they only have one gear, and the way it's shown there, it's low gear. The green shaft going out the back is the same gear ratio that's in all standard and automatic transmissions, a fixed speed of 2.7 to 1. Now that means the fastest the car can go under any conditions is 20 miles an hour at high RPMs, using lots of gas and making a lot of bad air. 35 USC 101 states an invention is patentable only if it's new and useful. The previous art used by Caterpillar against me in the IPR are not useful. And of course, if a patent is not useful, throw it in the trash. And that's what the prior art of those three people have done, thrown their patents in the trash. They cannot work. All of their patents and applications were abandoned, thrown in the trash. They did not pursue their designs or bring them to market. They would not work. I made that statement during the IPR hearing, that it is impossible to make any of them work. They were using a single speed 2.7 to 1 low gear ratio planetary. The new automobiles have at least 7 speeds in them, and the reason you need more speeds is so you get the RPMs of the engine close, so it changes gears every 150 RPMs. The first transmissions that came out that were 2 speeds, you'd have to run up to 28 to 2900 RPMs, and then it would shift into high gear. But now we figured out that the RPMs make bad air and use lots of gas, so they went to a 3-speed, and that changed the RPM ratio to about 500. But now they have 9 speeds, and that means that it shifts about every 150 RPMs, and the RPMs never need to get over about 22 to 2300 instead of 3500 RPMs. The CVTs used by Caterpillar as previous art against the 290 patent are 1 speed. In my opposition on page 8, I quoted 2 case laws stating that embodiments that are disclaimed during prosecution are excluded from claim scope. And that's the same thing the patent examiner used when he was examining my patent. I disclaimed the CVT and the planetary out of my patent during prosecution, withdrew and canceled all claims to those species. My 290 patent is a hydraulic clutch. The cases need to be held here in this court because Caterpillar broke the law when they claimed my transmission was a CVT when it was restricted out by the law.
I thank you both. It has been...
Can I make a statement?
Generally, the person who brings the motion has the right to present brief rebuttal. I will allow you to make a very brief statement in response to what Mr. Swenson just said.
Okay. What my patents, the only patent